I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this lesson on New England state courts. This lesson is the second in our series on state courts, so if you haven't already, please view the introductory class for your respective state before moving on to this lesson. All classes can be found in our FOI guide at NEFAC.org, as well as on our YouTube channel, 5 Freedoms. In addition to state courts, we also offer lessons on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. SBJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is brought to you by the New England First Amendment Coalition. Now, this session is going to focus on the courts in Connecticut again, and how to access court documents and hearings in Connecticut. And with us is attorney Bill Fish, and he's going to explain in greater detail how the courts work in the Constitution state. Bill, thank you so much for being here.
Thank you, Emily, and thank you, NEFAC, for inviting me back again. I really appreciate it and enjoy it. So as Emily said, we're going to talk today about accessing court records and court proceedings in Connecticut. And I thought I'd start by going over some of the history here in Connecticut. It's a little checkered in the past, but now we have a strong presumption in favor of court access. And I'm going to talk a little bit before I get into some of the details about some of the legal reasoning of the courts as to why there is such a presumption of strong access here in Connecticut. So let's start with the checkered history. About 20 years ago, the Hartford Courant, one of our clients, learned that there was a kind of a super secret sealed docket here in Connecticut. There was something called level 1 sealing, where the judiciary would actually not only seal a portion of a file, they would seal the docket. And so you couldn't even tell if the case existed or not. And they started doing this, it's not really clear when, but decades before that. And it might be a divorce case with a celebrity, it might be a divorce case with a politician, but there are certain people who had the ability to get into court and not have anybody know that the case was pending. And if you think about it for a moment, a docket sheet, which is the case caption, essentially acts as an index, right? To the case is now here in court, and you can go look it up, assuming it's public. But if the index is not even public, then you can't look up anything. And so the Hartford Courant and the Law Tribune and a bunch of other newspapers in Connecticut challenged that. It went up to the Second Circuit Court of Appeals, who said there is a qualified First Amendment right of access to court dockets. And over time, that all changed, and this level 1 sealing concept disappeared. And as a result of that whole situation that became public through the good reporting of some of the newspapers, including the Courant, the judiciary and the legislature both started really sort of looking at this issue more carefully and trying to decide, is this how we want our courts in the Constitution state to conduct themselves? And the acting Supreme Court, the Chief Justice of the Supreme Court, established a commission to look at this issue. Governor Jody Rell established a commission to look at this issue. I had the privilege of sitting on the latter one. And both of these commissions studied access to court records and court proceedings here in Connecticut. And as a result of that, the Connecticut judiciary, and I'm going to talk more about this in detail in a little while, enacted provisions in our practice book, which is like our code of civil procedure here in Connecticut. And those provisions dealt specifically with access to court records in civil cases, closing a courtroom in a civil case, access to court records in a criminal case, and closing a courtroom in a criminal case. So we have these 4 different sections in our practice book that I'm going to talk about in a minute that specifically lay out rules as to how and when and if court records and court proceedings can be closed here in Connecticut. There's also another important case that sort of came out of all of this, and it's called Rosado versus the Bridgeport Roman Catholic Diocese, Corp. And the Rosado case dealt with this exact issue of these provisions, and there's a lot of language in it at the Supreme Court level about when court records are public, because it went beyond just the words in the practice book that I referred to a moment ago. And it's such an important case that I wanted to just quote some of the language, because it really describes why court records should be public and why court proceedings should be public. And the good news here in Connecticut is that because the Connecticut Supreme Court and the Second Circuit, in that case I mentioned earlier, Pellegrino was the name of the case in the checkered history. Because we have these strong cases that talk about these rules and the theory behind them, I'm happy to report that Connecticut today, like I said at the outset, has a very strong presumption in favor of access. And let me just read some of this from the Supreme Court opinion in Rosado. It starts by saying public access to court documents traces its roots back centuries through the common law, stemming from the practice of open trials. The tradition of open trials made its way to colonial America and evolved into a presumption of public access to court proceedings and records that remains a fundamental part of our judicial system today. The rationale underlying the presumption is straightforward, and it truly is. Public monitoring of the judicial process through open court proceedings and records enhances confidence in the judicial system by ensuring that justice is administered equitably and in accordance with established procedures. And this is a great quote. The bright light cast upon the judicial process by public observation diminishes the possibilities for injustice, incompetence, perjury, and fraud. Furthermore, the very openness of the process should provide the public with a more complete understanding of the judicial system and a better perception of its fairness. Those are very important words that I just read, and they really, as I said, underscore the rationale and the importance of records and court proceedings being open to the public. As I said at the beginning about that Pellegrino case, we have a qualified First Amendment right of access to court records and court proceedings, according to the Second Circuit, and that's certainly a true statement. The Rosado case that I was just reading talks about the common law, which is a separate and independent source of access to court records and proceedings. But all of these put together create the rights that Connecticut has in the practice book today. And before I turn to those, one more point. The Rosado case talks about what are called judicial records. And that's the type of record as to which the presumption applies. And it sounds easy to say, a judicial record, that must be something filed with the court, and it certainly is, but it's not everything. And that's the point that Rosado made. It's almost everything, but it's not everything. And if you think about some things that can get filed with the court, there could be records filed under seal. I'm going to talk more about that in a little while. There could be records submitted to a judge in camera. You also have records that the parties exchange through discovery. So there are things that are related to litigation that don't become part of the public record because they're not what the Rosado court called a judicial record. So with that background, let me just talk a little bit about these provisions in our practice book. And as people like to say, this is sort of where the rubber hits the road. If you're ever looking to contest an access issue, whether it's an access to record in a civil case, access to a court hearing in a civil case, or the same issues in a criminal case, these provisions in the practice book are where you will turn. For civil cases, the practice book sections are 1120 and 1120A. And for criminal cases, it's 42, let me get the numbers right, 4249 and 4249A. So again, for civil cases, it's 1120 and 1120A of the practice book in Connecticut. And for criminal cases, we have the siren going on in the background, very appropriate, 4249 and 4249A. And all four of these provisions, even though they apply to different things, are very similar in their construction and in the rules that they set forth. So let's look at accessing documents in a civil case as by way of example. And the practice book says, and this is quite clear, except as provided in this section, you can't seal a court record. It's an absolute. So you have to look at everything else in the section. But that is the same for closing a courtroom in a civil or a criminal case. You can't do it unless it's authorized by the practice book. There's some minor exceptions to that I won't get into right now. But the practice book rules are what controls the vast majority of this. And the strong presumption manifests itself in the following. The court can only close a courtroom or seal a record if the order is, now let me quote it, necessary to preserve an interest which is determined to override the public's interest in viewing such materials. The judicial authority, which is the judge, shall first consider reasonable alternatives to any such order, and any such order shall be no broader than necessary to protect such overriding interest. What that means is if you're going to seal a court record here in Connecticut or close a courtroom here in Connecticut, you have to have identified, if you're the judge, an interest that is more important than the public's interest. And if you go back to the quote I read from the Rosado case a few moments ago, that is the genesis of the public's interest, understanding and making sure that our judicial system is working fairly and all the other things that the Rosado court pronounced. So if a judge is going to seal a record, they have to find something that's more important than that. And then what they have to do is only go so far as is necessary to protect that overriding interest. Let's give a simple example. If you're dealing with a case involving a sexual assault, the privacy of the victim may be something that's more important. And so there may be things that are done to seal a record or to close a courtroom in order to protect the privacy of that victim. And whether that's in fact the case will be decided on a case-by-case basis by the judge. And the parties can't decide this on their own. It has to be the court that does this. And Connecticut is so strong on this. Let me talk about another procedural question. If you go on the Connecticut judicial website, you will see a little section that says media. And if you click on that, even though this should be for the public generally, it does say media, you can find every pending motion in the state of Connecticut to either seal a document in a court file or to close a courtroom. They're all listed there because these sections in the practice book actually say that the court must give notice to the public of all of these different proceedings. So before a judge can seal a record or close a courtroom, there needs to be meaningful notice to the public. And the way that's done is it's on the judicial website. So if I'm following a particular case, I can go on the judicial website and find out if that case is subject to a motion to seal. If it's a case involving a sexual assault, there may be many motions to seal because there may be many documents being filed that the parties are asking the court to seal from public view. And as I think I said earlier, all of these rights are what are called qualified rights. Right? The language of these practice book sections make that clear. Except as otherwise provided in the section, thou shalt not seal. But that means the things that are provided in these sections can provide a basis for sealing a record or closing a courtroom. So if I'm a reporter, for example, following a criminal case, and I keep checking the docket, I will get an alert, or I can find it on my own, that there's a motion to close the courtroom. There's a motion to seal. And I then have the ability to go to court, whether it's a Zoom hearing or an in-person hearing, and contest that. And the way you would contest it is you would argue that these provisions in the practice book have not been satisfied. And of course, that can mean different things in different cases, but that is the genesis of how one goes about dealing with the closing of a courtroom or the sealing of a judicial record. Now, closing courtrooms are rare in Connecticut, but it does happen. There have been more than a few instances where we fought that. There's the right to appeal all of these decisions by a judge, and that right goes incredibly fast. It's 72 hours under the statute, under the practice book, that you have to appeal something like this. So if I'm a reporter and I'm contesting the closing of a courtroom in a particular trial or for a particular hearing, and the judge rules, okay, the courtroom is closed, you have 72 hours to appeal. No one's ever really decided what does that mean if you're at the beginning of a 3-day weekend, because 72 hours means 72 hours. But presumably it would roll over to the next opportunity where you get to file something with the clerk on the appeal. So these are all very important points, and I'll go back to what I said in the beginning. As a result of all of this checkered history, and as a result of these practice book provisions, Connecticut today has a very strong presumption of access to court records and court proceedings. And if one pays attention to the particular case, it's pretty easy in Connecticut to show up in court and to contest all of this. Now, having said all of it, these, as I mentioned, are qualified rights. They're not absolute. And there are many examples, the sexual assault victim is just one of them, where there could be a legitimate reason for a court to seal a record. One might be in-camera review. Here's a simple example in a civil case. The parties are asking the court about some particular document, whether it should be produced to the other side or used in the court proceeding. And one side says yes, the other side says no. And so they submit the document, what's called in camera, which means the judge gets to look at it privately as part of making the decision. If something has been submitted to the judge in camera, that is not a judicial record. It's not subject to access. On the other hand, if the judge says, okay, we're going to do ABC, whatever it may be, with this particular document, then it easily could become a judicial record, and it's something that the public would have a right to. We also have a proceeding where parties can file records under seal. And if you file something and it's called lodging it with the court, it's in a sealed envelope and you're asking the court to seal the record. What if the court says no? What happens? The public can't get access while the court's making this determination. It'll be announced, as I mentioned, on the website that this determination is in fact taking place. So if somebody wants to, as a member of the public or the press, participate in that process, they can. But when the judge makes a decision, the judge is either going to say, okay, record is sealed or record is not sealed. If the judge says the record is sealed, it stays in the file in a sealed envelope and people can't get it. If the court says it's not sealed, literally the sealed file can be returned to the person who filed it, and now they have a decision to make. They can file it not under seal, in which case it would likely be, almost certainly be public, or they could also try to take an appeal of that decision, although that's rare, where they would then appeal and the record would stay in the closed envelope in the clerk's office. So the rules there are actually pretty practical, would be the point I would make, in terms of how this process plays out. And so it's no longer the way it used to be 20 years ago, where you had this level 1 sealing where nobody even knew what was going on. Today, the process is pretty precise. We also have other situations where courts are closed. In juvenile criminal defendants is a classic example. We don't have access to the juvenile process in order to protect the rights of juveniles. That's by statute in Connecticut. Having said that, there's another interesting case, which is, I guess, part of what I would call the checkered recent history that came out of our General Assembly. Connecticut passed a law a few years ago where they said if a youthful offender is being tried as an adult, subject to all the adult rules, all the adult procedures, and all the adult criminal penalties, it doesn't matter. That case is still a juvenile case and nobody has access to it, including even a docket. In one of the strange aberrations to that, people are probably familiar with the Michael Skakel case, where he was accused of murder. At the time of the alleged crime, he was a juvenile, But the time all this court action is playing out, he's 50, 60 years old. That case, along with all the other juvenile cases, became sealed under this new statute in Connecticut. So just to say that again, it was a juvenile being tried as an adult, but because you're still a juvenile, Connecticut said those records are off limits, nobody can see them. The Hartford Courant, with the help of the Reporters Committee for Freedom of the Press, took an appeal about that to the federal court, claimed it was unconstitutional, and both the district court and the Second Circuit agreed and said, yes, you have this qualified First Amendment right of access, and you can't go back to that level one kind of ceiling, which is what this effectively was for these criminal cases. If you're being tried as an adult, you are an adult for all intents and purposes, and therefore you have access as the public and the press to the docket, to the case. And of course, the judge can close it or seal it like any other case if the facts warrant it, but they have to comply with the practice book. They can't just do it across the board. There are other issues in Connecticut. There's search warrants. Search warrants is another practice book provision on that. It's 36, let me get you the exact number. 36-2 in the practice book, and it said search warrants. I mean arrest affidavits. Excuse me. Arrest affidavits have to become public at some point. They're usually sealed for a short period of time, and then the court can continue that sealing of an arrest warrant if they want to. But in order to do that, they again have to comply with the practice book. So there's a presumption in Connecticut that arrest warrants are open to the public after a brief 2-week period of time. Arraignments are often open to the public, and you can have arraignments in hospitals, and the judiciary is considering how to deal with issues like that. Cameras in the courtroom. I'm trying to touch on all these issues before my time runs out. We have another set of practice book provisions about access to court proceedings by way of cameras in the courtroom. It's very precise. It lets the judge in the case make a determination, but the presumption is that, yes, you can have a camera in the courtroom. You can't have 20 cameras in the courtroom. There should be one, and you have to pool it among the different members of the media who are looking to do that. But we have a very strong set of practice book provisions. Let me get to the section there. It's 1-10, I believe it is, which deals with all the provisions that relate to how the media can cover a trial. I said 110 is 111 in our practice book. Connecticut does not have a traditional grand jury like many states that investigates crime and then has the ability to do what grand juries do, which is say, well, Mr. Smith or Mrs. Jones should be prosecuted. We do have an investigatory grand jury. Those proceedings are done confidentially, and with rare exceptions, those court records are not public. So if you ever hear about a grand jury in Connecticut, it must refer to the investigatory grand jury, and largely those records are not public. And an investigatory grand jury is a judge who's been appointed to investigate a particular situation, usually a criminal one. So those are the main points, Emily, that I wanted to cover. Let me end with where I started, which is, although Connecticut has a little bit of a checkered past, today we have very strong, very detailed rules that create access to courtrooms, court proceedings, court records, and we have a bunch of very strong cases in Connecticut that reinforce that by both explaining the rationale behind it, as well as reciting the rules and applying the rules in particular cases. And we also have the ability for reporters and others to monitor cases throughout the state on the judicial website, so you can tell if a particular case is subject to a motion to seal or a motion to close the courtroom, giving everyone the ability to say, no, don't do that. We don't think that's right. So that's where Connecticut is today. I'm proud to say that our firm was part of a lot of that over the years, and it's a pleasure to be talking again for NEFAC. So thank you very much, Emily.
Yeah, thank you so much, Bill. That was a great overview. Anybody who has questions, you can put them in the chat. There was one question that came up while you were speaking, Bill. And Annie was asking, in Connecticut, one can sign up for email alerts for a case. Do you know if those email addresses are subject to public disclosure?
It's a great question. I'm not certain, but I would guess no. The Freedom of Information Act, I should have said this earlier, does not govern anything that I've been talking about with the judiciary. It only governs the judiciary with respect to its so-called administrative functions, which would be typically budgetary things and things like that. So I would not view the filing of an email address with the judiciary as part of its administrative function, and therefore would not be subject to the FOIA. But I've never looked at that question. It's an interesting question. We also have a practice book provision which makes personally identifiable information off limits. I don't think that covers emails, but I'd also have to check that. But that's a fascinating question. I'm gonna go back and look at. And I put my email in many cases in order to monitor them. It's a very easy thing to do. So if people don't know about that, you can go on the judicial website, put an email and tie it to a particular case. And anytime a decision or motion or anything gets filed in that case, you get an email alert. So you don't have to keep going back to check the docket. You can get an alert from the court system automatically.
Oh, that's great. Great to know, and a great question. Yeah, I want to thank everybody in our live audience for joining us today. Bill, I want to thank you so much for walking us through, how to access the court documents and hearings in Connecticut. This was super helpful.
My pleasure. And
Right, and be
I
sure
look forward to the next one.
All right, excellent. That's what I love to hear. And to everybody tuning in, please check out our other episodes on NEFAC's YouTube channel and on our website, nefac.org. So thanks, everybody.